seeks reversal of the trial court's legally bereft decisions. Oh, Engeron's not going to be happy about that. Now, every representation made to the lenders was accompanied by clear disclaimers that lenders may reach a different result. Hey, do your own due diligence, they said. And lenders did, because they're banks. They're in the business of this. There were no victims here. There were no losses. Every single statement had an actual disclaimer, a clear disclaimer. And every counterparty who was involved in these deals was free to perform. And guess what? They did perform. Donald Trump's defense attorneys now appeal the nearly $500 million judgment that came out from Judge Engeron and Tish James, who, as we know, took her shoes off in the courtroom, stinking up the whole building. But Trump is now moving forward with this, saying, we can't pay this because it's illegal. You have no right to judge our own financial agreements with our own banks. We came to terms with them. Nobody was defrauded here. This was all agreed upon. And so Tish is abusing her office. The appeal comes from Trump's defense attorney, Christopher Keese, and we got a statement from him. Trump's defense team said the following, says, all right, listen, President Trump is a visionary and an iconic real estate titan who has been baselessly pursued and persecuted by New York AG Tish and her unprecedented abuse of power. During 44 days of trial, not one witness, not one complaint, and not one victim supported Tish's manufactured claims of fraud. To the contrary, actually, evidence established that Trump's net worth far exceeded what was even reported in his financial statements. And the sophisticated bankers involved pursued and enjoyed a long and satisfactory business relationship with him as a prized client. Says, this appeal from Christopher Keese seeks reversal of the trial court's legally bereft decisions. Oh, Engeron's not going to be happy about that. Which ignored the undisputed facts, refused to follow the binding mandate of the appellate division. So Engeron rejected what the higher courts told him to do, imposed draconian, unlawful, and unconstitutional penalties, and willingly allowed a reckless and politically motivated attorney general who took her shoes off, that's according to Alina Abba, in the courtroom, inappropriate, to meddle in lawful, private, and mutually profitable transactions. This was between Trump, the Trump organization, and the banks. And that's their business, not anyone else's. Now, this abject disregard for the established precedent, the Constitution, and the sanctity of the complex commercial marketplace of ideas in the New York legal system and the business community puts the sanctity at extreme risk. And indeed, such an outrageous miscarriage of justice is profoundly un-American, and a complete reversal is the only means available to restore public confidence in the integrity of the New York judicial system. Saying President Trump, therefore, today asks the appellate division to rescue the rule of law and to correct the innumerable and catastrophic errors made by a trial court untethered to the law or to commercial reality. Boom. That's from Trump's defense attorney, Christopher Keese. But this is what Tish is really all about. This came over from the New York Post. You can see this story tells us. New York Attorney General Tish James, she admits, this is her words, her quote, singular focus is helping Kamala beat Trump. That's it? That's your singular focus? Aren't you the AG of New York, the Attorney General? Don't you care about like what your citizens are doing? You have a different mandate. You have statutorily mandated duties in the law. Your singular focus is to help stop Trump. We know that. That's why your prosecutions are illegitimate. James, who's long denied having any personal vendetta against Trump, because she's a liar, obviously, slammed Trump as an existential threat. She offered up a glowing endorsement of Harris during an appearance on The Readout, which is that woman who wants to beat Trump. I'm focused at this point in time on securing the nomination for VP Harris and then ultimately getting her elected. That's what you're doing? How do you do that? Well, you prosecute Kamala's opponent. Isn't that convenient? Now, that is my singular focus at this point in time, says Tish, and continuing to stand up for the rule of law. There is none. She has perverted it. And representing the citizens of New York, which I guess, is this what they want in New York? Is this what they care about? This improves their lives every day. They wake up, they go, gosh, my life would be so much better if Trump got prosecuted. James stressed her sole focus when asked if she hoped Harris would appoint her as the AG. Oh, okay. So now we see what that's all about. So, well, I mean, I don't know if I could be the Attorney General of the United States. Could you imagine Tish, Attorney General, running the Justice Department? Oh my gosh. We'd be in the gulags in no time. They could find us. James stressed her sole focus when asked, do you think that you could be appointed AG for Kamala? Well, I don't know, she said. I have been prosecuting her political opponent. My singular focus at this point in time is to basically do that. Now, elsewhere in the interview, James doubled down, continued to unleash on Trump, who's accused her of leading a witch hunt because she has openly said that. James insisted that Harris was in the best position to go after Trump and all the things. So you can see the teams are forming now. And so they're not serving Biden, they're serving Kamala. So Joe was orchestrating orchestrating the political prosecutions. Kamala will just inherit them. Trump is appealing. You can see this is what it looks like. Beautiful document. Donald Trump's appeal of Tish's nearly $500 million judgment against him issued by Judge Engoron. You can see this is Tish James versus Trump and a bunch of other people up in the appellate division, First Department, New York Supreme Court, from Trump's defense. Writing, all right, Court of Appeals, New York. In this case, Tish James is now seeking to unwind and destroy and penalize very highly successful transactions between Trump, Wall Street banks, and decisions that left everybody deeply satisfied and had no impact on the public interest at all. What Tish has done violates centuries of New York case law. It's a power grab exceeding her authority, and she cannot sue as a government official to vindicate interests that are purely private between two parties, in this case, Trump and the banks. Saying Engoron here wrongly decided this case. Now, even though it belonged in the commercial division, where if it would have gone into the commercial division where they had a jurisdiction, it would have been dismissed. Now, having kept the case, Engoron, the trial judge, has been overruled with alarming frequency, multiple times in this very case. Notably, the Supreme Court, Engoron, blatantly disrespected you, Court of Appeals, and your prior rulings on the statute of limitations. He didn't even adhere to that decision, barely mentioned its reasoning at all, saying Engoron's erroneous decisions, if upheld, would bestow upon the New York Attorney General limitless power to target anyone that she desires, including her political opponents that she talked about when she was campaigning. And so based on this ruling, companies are not going to want to come here, and many businesses are fleeing actually already. The economic aspects of this decision are a disaster for New York. Tish has used the statute in a way never seen before. That statute, which is a consumer fraud statute, does not allow for a jury trial, and it doesn't apply to victimless transactions where the banks made money and Trump was happy. So to be clear, Court of Appeals, there is no evidence that the representations that Tish challenges in this case influenced any business decision at all. On the contrary, in fact, no party ever complained at all. Nobody alleged any default. Trump got the loans, paid them back. Every loan payment was made on time. All loans were repaid in full. Some before they were even due. Trump paid it off early. Now, every representation made to the lenders was accompanied by clear disclaimers that lenders may reach a different result. Hey, do your own due diligence, they said. And lenders did, because they're banks. They're in the business of this. There were no victims here. There were no losses. Appellant's business partners made over $100 million in profits, and they reaped extensive benefits from their relationship with Trump. They raved internally about their business. They were eager for more. If Trump's conduct constituted fraud, then that word has no meaning, because these were good deals that everybody was happy with. That means that Tish can do whatever she wants. She can seize and destroy private businesses. It's boundless. It's standardless. President Trump stands among the most visionary and iconic real estate developers in American history, changed the entire skyline of multiple cities. As trial evidence highlighted, banks and lenders vied eagerly for his business. They acknowledged his unique vision and unparalleled expertise, and they recognized that dealing with him would deliver tremendous value. Now, in negotiating these transactions, appellants Trump provided statements of financial condition. Those were estimates of Trump's properties. Those were accompanied by disclaimers advising his counterparties to perform their own due diligence. In fact, many of these greatly undervalued Trump's assets. President Trump is worth substantially more, not less than what he reported. When those assets were sold in the marketplace, the only objective assessment of their value, which is their sale prices, far exceeded Trump's own estimates. The old post office, for example, when he sold, that was $400 million on May 11th. On Trump's most recent statement, he only put that the OPO, the old post office, was valued at 130. He said, yeah, it's about 130. Sold it for 400. Same thing happened with Ferry Point Golf Course. Sold for at least 60 million, but on the most recent statement, he said, that's 22. He's undervaluing it based on unrebutted expert testimony. They can't prove otherwise. Mar-a-Lago is worth many hundreds of millions of dollars more than its valuation on the financial statements. Further, the statements did not reflect the inherent worth of Trump's unique brand either, which has enormous intangible value worth multiple billions of dollars that could have been included on those financial statements that were not. And so in short, Trump's estimates of his net worth were very low and conservative. They were not high, which is the exact opposite of what Tish alleges. In every project, Trump delivered tremendous value for his business partners. Lenders described Trump's performance on the development of the Doral Miami Club as amazing. That's their words, not Trump's. Really impressive. Like, dang, this dude can move. The condominiums that the bank helped finance in the International Hotel Trump Chicago were selling like hotcakes, their words. President Trump's, quote, vision transformed the OPO, the old post office, from a long abandoned empty shell into the most elite hospitality establishment in Washington, D.C., creating enormous value for everybody. The Ferry Point project languished for years, costed New York $120 million in fruitless efforts, wasting their time, until President Trump came in. He undertook it, transformed it into a resounding success. Lenders described their dealings with President Trump as sensational, superb. They boasted of a long and satisfactory relationship with the Trump family. Indeed, a huge swath of business partners are still doing business with the Trump family and benefiting greatly from the relationship today. Now, despite all that, Tish now attempts to interfere with Trump's business to unwind these private and successful deals. In fact, Tish campaigned on the promise, literally, that she would get Trump, and made this promise the single greatest point of her entire campaign. No statute authorizes this power grab. So the New York AG had to invent that by applying Executive Law 6312 in a way that no one's ever seen before. Yet the Supreme Court unaccountably rewarded Tish's, and that's Engoron. Engoron gave her rewards for her lawless efforts at every turn. In fact, in this order, and in this order, and in this order, they're all filled with errors. Among others, Engoron, which Engoron even struggled, okay, this judge, oh, this is beautiful. Engoron also struggled to understand basic banking concepts like a money market account, which valued the iconic Mar-a-Lago as worth 18 to 27 million, which is 50 to 100 times below its actual value, idiot. Now, according to trial testimony, the value is between 1.1 and 1.5 billion. He called it 18 million. It's now significantly higher based on current market conditions, because Florida is hot, baby, and MAGA is hot, baby. Similarly, Supreme Court somehow ignored the fact that Tish's star witness, is Michael Cohen, testified in this case too. He admitted on the stand that President Trump never directed him to inflate any valuations at all. Convicted perjurer, lied. The star witness for Tish's case doesn't even implicate Trump. So Engoron, the NIP's errors also included draconian financial sanctions, multiple awards of punitive relief against Trump's children. You hear about communists taking out different families, right? Take out the dad and just eliminate, execute everybody. Same type of things happening here. It hasn't happened with guns yet. They tried it, but not with the kids yet. So hopefully we pray for them too. Now, despite their lack of any direct role in any of this stuff, not one of the 40 witnesses who even testified at trial had anything to say about Trump Jr. or Eric Trump, more than any peripheral knowledge. But Engoron penalized them. So Engoron's decisions should be reversed for 7 reasons. And we'll read through some of the highlights. First, Engoron made an error and violated the law by not just ignoring, but also rejecting this Court of Appeals directive. They said the continuing wrong doctrine does not delay or extend the limitations period in this case. Just 3 months after this court says, sorry, that does not apply, Engoron, loser, shockingly ignored that decision, incorrectly held that it does apply, and then artificially resuscitated all of these old, long extinguished. Now, second, the plain text of the law in New York cannot reasonably and constitutionally even be applied to the unique facts of this case. Tish lacks the authority to dismantle any purely private, highly successful, complex transactions between sophisticated parties represented by elite law firms, accountants, and other service providers that implicate no public interest at all. She has no jurisdiction about this. This is between Trump and a private business. No one got defrauded. No one filed a complaint. So Engoron erred, violated the black letter law. Okay. She brought a claim under Executive Law 6312, and it doesn't allow her to do it. Engoron allowed it. The law says it doesn't allow it. And also ignored the Court of Appeals. And they're holding that the statute's prohibition of fraudulent conducts, okay, meaning it needs to be fraudulent. If it's going to meet the statutory requirement, you have to show a capacity or tendency to deceive. Now here, every single statement had an actual disclaimer, a clear disclaimer. And every counterparty who was involved in these deals was free to perform. And guess what? They did perform their own due diligence. They didn't take Trump's word for it. They're banks. There is no evidence that any challenged representation had any impact on any business decision at all. No evidence of any causation. There's no victims. There's no injuries. There's no losses. But Engoron nevertheless held that any alleged falsity violates it outright. Doesn't matter, right? In other words, it could be a mistake, not a fraud, and opens the door to destructive and punitive sanctions. So this interpretation violates the plain language. That's not what the law says. That's not what the case law says. It's not for mistakes. We don't criminalize or civilly penalize mistakes. And it raises grave constitutional problems if you can go in and find something like that. Engoron said, no, the statute is much lower. So you have a ton of leeway. Now, third, Engoron awarded $464 million in disgorgement penalties, saying it's based baseless, and it must be reversed in toto. Everything must go. Disgorgement, if you're going to require somebody to be disgorged of money, it requires a showing that the misconduct caused the supposedly ill-gotten gains. So there was some misconduct and causation. So somebody did something that caused something else to happen. In this case, illegal gains. Here, there is no evidence that the supposed misrepresentations affected any terms of the agreement. On the contrary, because the representations had their own disclaimers and the lenders did their own due diligence, overwhelming evidence supports the opposite conclusion. Trump didn't cause them to give him certain discounts or anything like that. He said, this is what I think it is. They said, okay, that's your opinion. This is our opinion. And they came to terms. Now, fourth, the $464 million disgorgement award is also unconstitutional under the U.S. Constitution, excessive fines and due process clauses. The monetary award is a punitive penalty imposed for retributive and deterrent purposes. It's both grossly disproportional under the Eighth Amendment and their excessive fines clauses, and it's grossly excessive under the due process clauses. Now, fifth, the judgment on the second through seventh causes of action must also be reversed. There is no plausible showing of materiality. There's no intent to defraud. In other words, these financial statements from Trump saying, I think I'm worth this, didn't cause any material changes to the terms. There's no intent to defraud in any of that because it's an open disclosure and other necessary elements of the underlying provisions of the penal law. Now, six, the sweeping and intrusive award of the injunctive relief must also be reversed. This power does not even apply to this case at all. And there is no likelihood of continuing violations because there wasn't a violation here. And also, Engoron violated the law by allowing this in the first place because all of this conduct was clearly lawful. And seventh, the Supreme Court, Engoron, engaged in a series of erroneous valuations, including with Mar-a-Lago, calling it $18 to $27 million. Obviously, that's a tiny fraction of what it's actually worth. And these errors infected the subsequent trial. And so in sum, this politically motivated prosecution is attempting to penalize purely private, proper, and lawful conduct by illegally and unconstitutionally applying this law that would give Tish boundless authority to target her political opponents, as she's doing now, working for Kamala, as we saw. It would render the statute unconstitutional, must be reversed from Engoron. So a series of questions here on all seven of those. We know what the complaint looks like, and they zoom in on the details here. But Engoron is now somebody who is going to be facing this appeal, and we'll see what the Court of Appeals does. So in New York, we don't expect much from the Court of Appeals. But after they reject this, it will be up to the actual appellate court in New York, which is their Supreme Court, and the rest from there may take us up to the United States Supreme Court, depending on where this goes.